This hasn't received a whole lot of attention, but there's a concern among some victims' rights advocates and prosecutors over parts of New York's new criminal justice reform bill. Starting at the first of next year, prosecutors have to hand over all evidence to defense attorneys within 15 days of an arraignment, as opposed to, say, the day before the trial. In our area, we have some who worry this will endanger victims and others who say the change is long overdue. Jennifer Sullivan combats domestic violence at the Willow Center. She likes much of what's in New York's new criminal justice reform package, but the part that tells prosecutors to hand over all evidence within 15 days after arraignment troubles her.
Often right after a really traumatizing incident, people don't want to come forward, want to uproot their life and go to a shelter, for example. So having some time to just deal with what they've been through is a requirement and something that they should deserve to have and deserve to be safe during that time.
Monroe County District Attorney Sandra Dorley says her office historically handed evidence over within 45 days, adding handing over names and addresses only 2 weeks after arraignment could encourage witness intimidation or tampering.
Before we were giving that information out, but again, it was, well after, the crime. And, sometimes cooler heads would prevail, time would expire, and giving it out 45 days, didn't cause as many issues as I see giving it out within 15 days.
But defense attorney Mark Foti, who supports the change, says this about Dorley's concern.
The idea that it's disclosed in the beginning of the case doesn't really create any substantive reason to believe that there would be a higher degree of witness tampering than there is in any other case. But it does create a level of fairness between the prosecution, who knows what evidence they have to employ or what their case looks like, and the defense, who now has a picture of what that looks like and can make decisions based on that.
Assemblywoman Jamie Romeo also supports the change, saying the law provides prosecutors the ability to petition the court for a protective order shielding ID information.
Because we're not the first state to do this, I think people feel more confident that we've left the resources and the tools in there for prosecutors to take if they feel that they need to, and to leave that into a judge's decision. This just creates more of a set standard now for both sides to give them that same amount of time before they go to trial.
It looks like a lot of this will come down to how judges respond to the new law, whether they'll grant numerous requests from prosecutors or if they feel pressured to stick to the 15-day everything gets handed over rule in almost all cases. Again, this will take effect on January 1st, and we'll be watching from there.